New powers for contracting authorities to exclude companies from winning work with the public sector, a whole new process for banning suppliers from public procurement, plus the UK's first centralised list of debarred suppliers managed by the Cabinet Office. Wow, the Procurement Act is really set to change the way the public sector buys goods and services. But how exactly will the new supplier exclusion and debarment regime work? And how will it affect how the private sector does business with contracting authorities in England and Wales? I'm Ben from Tussell, and this is Supplier Exclusion and Debarment Explained. What is supplier exclusion? The Procurement Act is set to expand on existing rules that allow public sector contracting authorities in England and Wales to exclude suppliers from the procurement process for a range of reasons. Under the new legislation, contracting authorities will not be obligated to consider a supplier's bid if the supplier or any connected persons meets specific grounds for supplier exclusion. So what are the grounds for supplier exclusion? The Procurement Act specifies a list of mandatory and discretionary reasons for supplier exclusion. These may include previous criminal offences, national security concerns, poor performance in existing or historic contracts, professional misconduct, labour violations, or competition law infringements. And these exclusion criteria apply for offences and misconduct committed both in the UK and abroad. So, what is the procedure for supplier exclusion? When choosing whether to exclude a supplier, a contracting authority must consider whether the issue identified with the supplier is likely to continue to exist. If the issues with a specific supplier have been sufficiently remedied or fixed, a contracting authority may not exclude the supplier from the procurement process. The Procurement Act introduces an amended self-cleaning test which suppliers may use to evidence the ways in which they've mitigated the risk of previous misconducts being repeated. Suppliers facing the possibility of exclusion will be given the opportunity to present their case as to why any historic infractions will not happen again. What is the supplier debarment list? The Procurement Act mandates the creation of a new centralised supplier debarment list, which will be managed by the Cabinet Office. Just like with supplier exclusion, inclusion on the debarment list may be based on either mandatory or discretionary grounds. Generally, suppliers included on the mandatory debarment list will be excluded from all procurement for a specified period of time. However, when national security is cited as the reason for debarment, the debarment list must specify which type of contracts the supplier is debarred from. The supplier would then be allowed to bid on contracts that do not fall into this category. For suppliers on the discretionary debarment list, a contracting authority may voluntarily choose to exclude a debarred supplier from a particular procurement. What is the procedure for inclusion on the supplier debarment list? For a supplier to qualify for the supplier debarment list, a government minister must have conducted an investigation and found the suppliers subject to exclusion. During this investigation, the supplier must be given the opportunity to make representations in their defence. If the minister decides the supplier must be debarred, the minister must notify the supplier of this finding. At this point, an 8-working-day standstill period begins, during which the supplier may issue legal proceedings for interim relief. Once on the debarment list, the supplier will have 30 days to launch an appeal against the debarment decision. However, there are limited grounds for such an appeal. At any point whilst on the list, a supplier may petition to be removed if they believe that the necessary self-cleaning has taken place. How can suppliers prepare for the new regime? To prepare, suppliers should seek to identify reasons why they may be considered excludable or eligible for debarment. When investigating, it's important to consider both the organisation as well as any connected persons such as beneficial owners, directors and subsidiaries of the company. If any reasons can be identified, suppliers may choose to begin the self-cleaning process now. Are you worried about how the Procurement Act may affect your business? Tussell provides data-driven insight on the public sector market so that no matter how the procurement landscape changes, you'll always be ahead in understanding the top frameworks, opportunities and trends in your market. Head to the description to book a chat with the Tussell team and learn how you can start using hard data to drive public sector sales and de-risk your public sector market strategy. Or send us a message at contact@tussell.com. I've been Ben. Catch you next time.